So we're moving on to the second part of our company law. Not really, more like the second topic, not the second part. So remember, I said there are 4 parts. So let's not confuse parts with topic. I said there are 4 parts. And the first part deals with the formation of companies. And that means under that, we looked at the nature of business entities. So sole proprietor, partnership, and things of that nature. And today we're looking at steps you take in forming a company. And then the other thing that we look at probably in the next lesson will be membership. So that will be the membership. That will be part 1. Part 2 will be dealing with financing companies. So right now, I mean, in the last class, not like Friday, but in the last class, in the other class that we had, the last 2 classes, we said when it comes to companies, you obviously have to decide what exactly are you going with? Are you going with the sole proprietor? I mean, with business, not companies, business. Are you going with a partnership? Okay. Are you going with the cooperative society? I mean, these things will still achieve some goals. Or do you just want to create a company, corporation, company? Now, since this is company law, we are interested in creating companies. And that means we now need to understand how exactly do you form a company, okay? So what are the steps involved in forming a company? And that's the steps involved, the roles you're going to play, the problems that you can face in the process, well, the challenges and things of that nature. So let's start with that. And before we go there, just a simple question. If somebody comes to you and says, hey, I'm thinking of starting my own company, okay? How exactly do I form this company? What are you going to tell them? Guys, let's participate. What did you tell them? What are they supposed to do based on what you know? Eric and Planta? Guys, yeah, registration of the company. Anything else? What else? Come on, guys. Changamke, you know, the exam date is already out there. So if you're playing this game of Kunyamaza there and then in April you start asking, no one is going to answer your questions by then. Okay. The objectives of the company, yeah. So that's something else they need to know. Okay. So hopefully you're going to participate better than that. Now, first of all, the first thing we need to directorship, right? That's something else. What else? The type of company, the type of the company, they also need to figure that one out, right? So these are things they are supposed to know, right? So all that stuff. First of all, the thing that I want you to understand from a legal perspective is that the people who form companies, okay? If you create a company right now, legally, you're going to be known as a promoter. So that's the first thing I want to understand. If you form your company, if you go ahead and form a company through whichever process we shall look at, you're going to be known as a promoter. So, I mean, okay, first of all, there is no like a specific definition of a promoter, but based on this case, okay, the Ty Cross v. Grant, the judge simply said that a promoter is a person of one who undertakes to form a company, okay? That's pretty much the thing by taking all the steps involved. So think of it this way. If, let's say, this guy called John here, okay? So John decided that they want to form a film company, okay? Film company. At this point, John is just a person, right? So the question then becomes, what is the relationship between John and that company? Because as we saw in the last class, that a company is a different person. And that means the person who forms the company is also a different person. Now, it's important for you to understand that the person who forms a company may not necessarily want to be part of that company as it goes on. So once you understand how companies operate, we tend to operate under this assumption that if you form a company, then you want to run it. It's not necessarily the case. You can form a company for many reasons. You can form a company simply because you want it to buy other companies. You can form a company because you want to hide your property. You can form a company because you're avoiding certain legal obligations. Okay? I don't know if you understand each other. How can you form a company because you want to avoid legal obligations? Anybody? Because you guys are doing company law and now you need to start thinking like people understand companies. Give me an example, like how can you form a company? You don't want to run it, you just want to avoid some legal obligations. Eric, how does that work? Planter, come on. Changamke. If you have no idea, just have no idea so that you can move on, so that I don't sit here waiting for your response. Kumbe haikuji. So how does that happen? Right? Okay, Eric, what do you think? Yeah. So think of it this way, okay? Let's say you form a company. Let's say you form a company ABC. Okay? And ABC is supposed to make cars. So planter, pay attention. But then this ABC needs employees. That's up. And you've just realized that employees, thanks to like what is it called? Kotu or something. Kotu ndio ile akina Tony. Thanks to Kotu, employees just demand a lot. And they're constantly going to court and they want to sue you and all this stuff, right? So I hope you're together, Planter. Eric. So these employees, you own ABC Limited, which is supposed to be producing cars. But then you've realized that thanks to the labor union, these employees are constantly going to court. They're constantly suing. So you can employ them here and then risk what? Lawsuits and a bunch of stuff. Or you can form another company. Let's call it 123 Limited. So guys, pay attention because these are the things, you're doing accounting. But where are you going to be doing accounting in a company? So you need to understand how these things operate. So you form another company, call it 123 Limited, and this company is just a labor company. It's just a labor-related company. The job of this company is to find employees. And then instead of employing these guys at ABC, you employ them at 123. So they're employed at 123, and then 123 gets into a contract with ABC, where 123 supplies workers to ABC. So these workers work for 123. And so ABC simply pays 123, and 123 pays the workers. So if there is any issue, these guys will be like, yeah, and then they're like, no, just sue this company. So they sue 123, and no matter the amount of lawsuit, the money this company has is limited to what it's being given by that. So now that company is safe, and this one deals with anything. If issues occur, then you can just close that company and start another one. Okay, start another one. 4, 5, 6 Limited. So you see, what are you doing there? This entire company is created to avoid legal actions or to avoid employees misbehaving. Now, that's just the point. The point is that it's not necessarily the case that if you form a company, then you want to be there running that company, dying with that company. It's like, nah, I can form a company for a totally different reason. You understand each other? Tunaelewana? Okay. So now, with that in mind, right? So with that in mind, the people who form these companies, so if John, we're talking about John, if John forms a company, at that point, John is a promoter. So before we go into the steps involved in forming a company, we first of all need to start by understanding exactly what is it that is expected of promoters. What are they supposed to do? What problems could they land into? and things of that nature. In fact, to make that easier, look at this case before you even look at anything. Let me just show you a sample question from KASNEB, so that you don't have to answer it now. We'll answer it, or definitely will answer it at some point. But just look at this question. This question here. Are we capable of seeing that? Eric and Planter, can you confirm? Just switch the screen.
Yes, I can see.
All right. So look at this question. This one, question 1D. These from the last sitting, 7th December 2023. So the last sitting. What are we told? You're told that you have Tom, who is acting as a promoter of Tom Company Limited. Meaning what? He's one of the people who started that company. Okay? So this guy is acting as a promoter and is negotiating a lease agreement for office space at Upper Hill, Nairobi. So yeah, so the problem is you're negotiating for a lease. So the question is that lease going to be binding Tom? Or is the lease supposed to bind Tom Company? So what should Tom do to ensure that the company, that once the company is formed, the lease agreement does not bind him? The lease agreement binds the company. So these are problems that you're going to face as a promoter. This is the reason why it's important before you even go any further. Before you start saying, step one, register the companies, do business search. It's like, yeah, those are things you can Google. First of all, do you understand your legal position when you're starting a company? Do you understand the role that you're going to play? Do you understand how things can turn out if things actually go wrong? Okay, that's the first thing. Eric, I hope you are still together, even though there seem to be some network issues. Just if you're together, you can just, like message or something. Okay. So this is the reason why it's important to understand the promoter. So let's go ahead. We'll come back to that question at some point anyway. So as a promoter, what are your duties if you're starting a company? Okay. If you're starting a company, you need to understand that there is what is called the fiduciary duty on promoters, which is similar to what you find in the law of agents, the relationship between an agent and a principal. Okay. So that fiduciary duty means that a promoter is supposed to either disclose any profit or potential conflict of interest to the board of directors or to the shareholders. Okay. Meaning what? Meaning, look, you see, look at this scenario here. Let's say, okay, we've already used Tom. So let's say this guy called Jack. Let's say Jack works in the government. Okay. And probably they work in the government, procurement, or disposal. It doesn't really matter at this point. Who cares where they work? So maybe procurement or disposal, one of those. And then the government is now about to sell cars. They're disposing their cars. So Jack, but I hope you're following along, because if you miss something here, it becomes a problem. Are we together?
Yes.
So what does Jack do? Jack goes ahead and forms a company on the side. Forms a company called Jack Incorporated. Now, when the government is selling these cars through, say, auction or something, so let's say one car goes for 700,000, and then this company buys them. Since Jack is the one who's doing this, is part of this, so Jack makes sure that the company buys those cars. So he buys 10 cars, meaning he spends 7 million. Now, that's Jack. And then he goes ahead. So this is a company has formed, and then he goes ahead and so the company doesn't really have money, but they've already bought the car with a loan. And so, or Jack is the one who gives the company. It doesn't really matter. The point is he buys the cars, right? And now later, Jack tells the people who owns this, the board, the shareholders, and all that stuff, that you guys owe me 7 million because I used my money to loan the company to buy these cars. So you need to pay me that money. So you see, the problem is that number one, the relationship between Jack and the company. Jack is supposed to make some profit and is using that company to make that profit in a way that other people are not aware. Or even worse, let's say he buys the car for 700 and then decides to sell them for $1 million each. So that's 10 million, which means, 3 million profit. Okay, so now he's keeping a secret, 3 million profit. So what is going on is that Zach used his position, and a lot of these actually happens with these government disposals of property and stuff. So this is a case where a promoter created a company with a sole intention of profiting. Now, there is nothing wrong with that. There's nothing wrong with creating a company so that you can profit. But there is everything wrong with creating a company and trying to profit from that company and failing to disclose the truth. So that is the issue as far as this is concerned. And so in this case, that is basically what Jack is supposed to disclose. So that is the reason why you are told here that as a promoter, okay, as a promoter, you have a duty to do what? You have a duty to disclose any potential profit, okay? Disclose any potential profit. Who are you disclosing to? You're disclosing to other directors, you're disclosing to shareholders. Okay, any question before we come to the question of conflict of interest? Question?
William, I have a question.
Mhm.
What is the difference between a promoter and a shareholder?
You see, a promoter starts the company. A shareholder actually bought shares in the company. They own the company through the shares they bought. So it's not really a must that if you start a company, you become a promoter. Sometimes you don't. I mean, if you start a company, you become a shareholder. You can start a company and then fail to be a shareholder. Okay. Like let me okay. To avoid easy mambos let's make it real. So for example, let's say John has 2 kids. So John has a kid called Mary and has another kid called Tom. Now, these children are probably, let's say they're twins, so they're 21 years old and they are broke. So John is their dad. Okay. But these children have a business idea. Okay. And so they present this idea to their father. And the father says, okay, I'm going to help you. I'll help you set up a company and all that, blah, 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 blah. So as John is helping them setting up the company, doing the registration, all that stuff, Now, at this point, John is a promoter, helping these kids do all this stuff. But then when it comes to that part where the kids are now writing members, they're writing the name of members in that company or shareholders, if they like, then they just write Tom and Mary. John is like, your father was a gift to you. I just, I don't want part of the company. I'm just helping you set it up. So you see, at this point, John was a promoter. But then when the company starts running, you realize John's name is not there. So he's not a shareholder. He doesn't have shares in that company. So that's the difference. Is that clear?
Yes.
Is it? Oh, yeah. So that's the difference. So it's not, again, as I said, it's not entirely the case that you create a company and you want to be part of it. For example, if you're creating a holding company or even a trust and you don't want to be part of it because you don't want people to know what you own. But the challenge is you need to put somebody there whom you trust. And so if you have somebody you trust and you can control their actions, so in that case, you see what is happening. You're not even part of that company, and yet the company is yours. Like these things you hear, that person is just a proxy. Or these celebrities that you see, like they always on the media talking about how much money they have, but they can't tell you their business. It means it's not their money, it's just someone else's money they're holding on to. That person's name just doesn't want to appear in the company. So it's not always the case that people start companies and they want their names there. It depends on what you want to do with that company. Okay. Any other question? All right. So we said you have to disclose profit. You also have to disclose a potential conflict of interest. So what sort of conflict of interest can occur as far as promoters are concerned? Again, let's look at this example. So the first one was just this guy making profit. But now let's say we have a company called ABC Limited. Okay. And in this ABC Limited, we have three shareholders. There is John, there is Mary, and let's say there is another one, let's say there's Jane. Okay. So these are the shareholders. Not shareholders, sorry. These are the promoters, sorry. We're still not talking about shareholders. We'll come to shareholders later. So these are promoters. These are the people who are starting this company. So they're the people who are in the process of registering the company. But then John, okay, has a wife. So John has a wife called, what female name do you have? We have Mary, we have Jen, name again. I can't think of any female name. Oh, if somebody's called John, their wife anaweza kuwa anaitwa nani? Come on, give me an example of a name.
Sarah.
Anna. Right, let's go with Anna. Right, so John has a wife called Anna. Anna is running a marketing company. Let's say she has a marketing company. Okay. And so while these three people are in the process of registering this company, they said, look, speed, okay? Business is all about speed. They're like, we don't have to wait until you finished registering the company. Let's start marketing this company with coming soon and things of that nature. And so these three are like, all right, we need to find a marketing company. And then they have a choice. There is this marketing company one, and there's another one here too. And then now they're like, okay, so which one do we go for? And John, since he seemed to have more power, says, let's go with this company. But these two people, Mary and Jane, have no idea that John is married to Anna. Then they just think, okay, this guy probably likes that company, so let's go that company. So you see, what is going on here is that there is a conflict of interest. The reason why John is interested in this company could be either one, because of the wife, or two, because it's actually a good company. We don't know. So the only thing you can say for sure is that there are interests which are conflicting. How good is the company versus the fact that your wife works there? So those are two things which are conflicting. And it's John's duty to disclose that information to the other guys. Like, look, guys, before we proceed, I want to say something. There's this company, it's a good company, but my wife owns it. So if you're going to go forward and pick it, I just want to know it's a good company. Here are the track records and my wife works there. Otherwise, if that company, if ABCD undertakes a loss as a result of this company, then John is going to be held responsible. That is a thing in terms of disclosing any profit, as well as disclosing any potential conflict of interest. Any question up to that bit? So as a promoter, these are your duties. These are things you're supposed to do. You're supposed to do all this stuff. Any question? Now notice, when there is a conflict of interest, who are you disclosing to? I said you're disclosing it to board of directors. If there is an independent board of directors, then there is that. Or you're disclosing it to shareholders, okay, if they're there. Now, remember the promoter is not an agent of the company. Meaning what? You see, when we talk about agency relationship are kind of fairly straightforward. An agency relationship is where there is a person, let's call this person the principal. And then there is another person, in this case, the agent. Okay. And the agent's job is to represent the principal to a third party. So for example, a landlord and a caretaker. So the landlord never really have to meet, what are they called? The landlord doesn't have to meet the tenants, but the caretaker has to meet the tenants on behalf of the landlord. So in that, or even the agent, if there is an agent. In that case, the agent of the caretaker represents the landlord, who is the principal. And the same isn't true about companies. So a promoter doesn't necessarily have to act on behalf of the company. Their job is just promote the company. And that is the reason why, if you look at this case, this question we started with, okay, you're told Tom is acting as a promoter, and now he's acting on behalf of the company. But what can you do to make sure that that agreement is not personally binding him? Because that's what you're trying to avoid. You're trying to bring up the case, the fact that that person is not the agent of the company. So those are duties. Now, what if they breach these duties? What if they fail? Okay. What if that happens? What if they fail to uphold those duties? Like, what if you go ahead, okay, and pick a company that this business is supposed to do business with, but fail to mention that your wife works there or your husband works there, or make some secret profit and fail to disclose that as a promoter? What are some of, because in that case you failed, you breached your duty as a promoter. So in that case, what happens to you? And you're told that number one, if you sell your property, okay, to a company without disclosing these, then the company can walk away from the contract. So think about it. You formed ABC as a promoter, and then you are selling your car. So let's say you have a car. The car is worth 1 million, but then you decide to sell that car to this company for 3 million. So what are you doing? Why would you do that? Now, because it's going to show in the company's statement of financial position, the balance sheet, that that car has an asset worth 3 million and it has a debt of 3 million. So everything is balanced, except the car is actually worth 1 million. But then the company has to work hard to pay that, okay, because they don't know otherwise. So it's your job to disclose that information. So supposing you don't disclose that, and then it turns out that somebody finds out the truth, then the company can walk away from that contract. They can say, no, we didn't want to be bound by this contract. This person got us into that contract, okay, the promoter, by failing to disclose. So that contract is void and we are resigning it, okay? We are walking away from the contract. Are we together? Today, Eric, Clinton?
Mm.
Okay. Eric, I hope you can hear us. Kindly confirm if you can, because yeah. So that's number two. So if you sold your property, like in this case, then the company can say, no, that's, and then number two, the promoter may have to account for the companies, to account for the profit you made. So you kept a secret, like in this case, you're supposed to make like a 2 million profit, right? So tell us, okay, this 2 million, how did you get it? So that could be a remedy. So usually, again, remember the duties, okay, to disclose any potential profit, as well as to disclose any conflict of interest. And if you fail to do that, there are going to be some repercussions. And these are some of the problems that you're going to face if you fail to do that. Okay. So now the next question is, what do you think? Should we be paying promoters or not? Should a company pay promoters or not? What do you think? Are they supposed to be given money? What do you think? Come on, guys, chop. Let's do this. Manta, what do you think?
So I think the company should pay.
All right. Why? Why are they being paid? Hmm. Now, the other version of this story, which makes it more personal, let's assume if you have a child, should your child pay you because you gave birth to them?
No.
Yeah, or you want to say, yeah, for personal reasons, what if I'm broke? Okay, no, why? Hmm. Any reason? Like, how do you justify that? It's like, no, why? Because there is no contractual agreement. There's nowhere where you and the kid agreed that, you know what, here's the deal. I'm going to give birth to you, and then you're going to pay me. So it doesn't. You decided to do that. So that's the same thing with the company. The company didn't tell the promoter that it wants to be formed. And therefore the company doesn't owe the promoter any payment. Okay. And so that's pretty much how that works out. So the same case is going to apply to, what is it called? The promoters. So companies don't necessarily, I mean, there is no that contractual obligation. So companies are under no obligation to pay the promoters because the promoters took it upon themselves. Okay, they decided out of their own, you know, will that they're going to to do business rather to form this company. So companies don't have to pay promoters. They promote, but it's not that simple because in some situation a company can decide, or rather through the articles of association, something that we shall look at in a few minutes. So through the articles, okay, it could be the case that the company has decided that is going to compensate promoters. That's a different story. But legally speaking, there is no, like a promoter has no legal right against a company. Okay, because there was no agreement in which the deal was create a company and then the company is going to pay you. So under that circumstance, well, it's fairly straightforward. So let's see. But what if we change the circumstances? For example, in a situation where there is that article of association. Okay, first of all, is what I want you to remember. The general rule is simple. A promoter has no legal right against the company promotes because there was no agreement. Okay, but the directors, once you create a company, okay, you can decide that we are going to compensate the promoters, or we are going to thank the promoters, okay, or we're going to pay them, if you like that term. So that can happen. So if you're asked these in exams, the first thing you start by saying is that there is no legal obligation, okay? There is nothing legally obliging the company to pay the promoters, but the directors can, okay? The directors can put it in the articles of association, or the directors can decide that the company can pay the promoter or can compensate the promoter or can thank the promoter through some form of payment for promotion or promotion expenses. And that is why in the articles of association, there is a part which talks about preliminary expenses, which could be part of the promotion expenses. Making sense? Is that making sense? Okay, so that's the thing with the, so what have we looked at so far? One, we know promoters are. Two, we know what they're supposed to be doing. Three, we know what happens if they fail to do what they're supposed to be doing. Four, there is the question of paying them. And so we know that. So now let's talk about the question of the preliminary expenses. Okay. So let's talk about that, the preliminary expenses, rather the pre-incorporation contract, sorry, the pre-incorporation contracts. What is a pre-incorporation contract? You have to understand that again, look at this example here. So, fact, let's just, okay. So let's say this John guy, John is in the process of of creating or registering, creating a company. So the company in this case is 123 Limited. So what does that tell you? The company is yet to exist. As of now, it does not exist. Sasa. Let's understand that, because this is how you end up understanding the pre-incorporation contract. So the company doesn't exist. But then John goes ahead and starts doing business deals on behalf of a company. On behalf of which company? On behalf of a company that doesn't exist. The company is yet to exist. So all these deals that John is doing, looking for office, whatever it is, okay, having a website built and things of that nature, he cannot just say, well, the company is going to pay for that. Because for starters, the company doesn't exist. That is an equivalent of a parent. Let's say they're expecting a child, and then you go and start buying clothes for the kids, and then you're telling the person who's selling you those clothes, these are for this kid, and the kid will pay. So remember, the kid is non-existent. They're not even in the picture. What you're saying is you're simply assuming they'll come into existence. But the reality is, you on the other hand are there, the seller is there. So what you end up having is a pre-incorporation contract because the company is yet to be incorporated. So number one, what is the effect of pre-incorporation contract on the company? And number two, what is the effect of pre-incorporation contract on the person who's acting or purporting to act on behalf of the company? So what do you think? If you get into a contract on behalf of a company that doesn't exist, what is the effect of that contract to the company? Is the company bound by that contract? Come on, guys. Let me quickly respond and then we move on. No. So the company isn't bound by that contract. Why? Because the company doesn't exist. Okay? So if the company isn't existing, then the company is not bound by that contract. So it doesn't bind the contract. Now, number two, what is it? Because the company is yet to exist. Number two, what is the effect of that contract on the person who's acting on behalf of the contract? So is that person bound? If the company is not bound, then who's going to be bound by that contract? The promoter. Okay. So that is now bringing us to this question. So now you can look at this question and see how it works. So can you look at that question again now and understand it so that you can move on? So now do you see the problem there? Based on what we've just said, if things are left the way they are, who's going to be bound by that deal, the lease agreement? Who's going to be bound? Guys, you do realize this is an exam question. So if you're quiet, nothing else is going to happen. You've already started revising. So these are the questions you should be expecting. I'm not asking you what is the answer to this question. I'm asking if things are left the way they are, who will be bound by this lease agreement? Is it Tom Company Limited or Tom Bwire?
Tom Bwire.
It's going to be Tom, right? Yeah. And so now the challenge is, what can we do to ensure that Tom isn't bound? And so that takes us to what we've already covered, okay? Whenever a promoter is acting on behalf of a company, what are the things that promoter is supposed to do? they're supposed to disclose. Yeah. They're supposed to disclose that to the potential shareholders. They're supposed to disclose that to directors. In this case, they're supposed to disclose that to the, what is that? Whoever is running this office, okay? Disclose that to the person they're contracting. I don't know if that's the client or they just say the other party, okay? So they're supposed to disclose that to the other party, to the directors, to that. And obviously, they should also ensure that the articles of association covers preliminary expenses. So this becomes part of the preliminary expenses, okay? So you get that. Doesn't really mean that you need to say like, okay, 4 things or whatever it is. I mean, at this point, you still get the mark, but just giving you more points. So the issue there is, do you understand what promoter is? And do you understand the fact that if a promoter does any business on behalf of a company that doesn't exist, that becomes part of the pre-incorporation contracts? And do you understand that pre-incorporation contracts will not bind a company unless otherwise stated? And number 2, do you understand that a pre-incorporation contract will bind the person who's acting on that on behalf of that company, again, unless otherwise stated? So under what circumstance will none of those things that you just said happen? So that is what you're being asked in this question. Right. And again, another question, this one. Discuss the legal responsibilities and the potential liabilities that a promoter may incur during the incorporation stage of a company. What do you say there? What do you say here to Jafundisho? What are some of the responsibilities? Just talked about those things under the duties. What did you say? They have a duty to disclose what and what?
A promoter should disclose any profit or potential conflict of interest.
The potential conflict, secret profit, okay? In failure to do that, liabilities, they become liable for any contract they get into on behalf of the company, okay? And if they sold a property to the company can resign that contract, right? And they're also required, or the company can force them to explain or to justify the profit they made. So that is what you're being asked here. Just being asked, okay, do you understand the duties of our promoters and what happens if they fail? So what are their duties and what happens if they breach any of those duties? So, no, yes, if they're like exams, they're very easy. It's just duties and remedies for breach of duties, and you get your 6 marks. Now, we already talked about this too. So, any question? In the last class, somebody was like, when are you going to look at past papers? And they realized that whoever asked that is probably not here today. But see, this is how we are going, we study. We study, we look at the responsive, the corresponding questions, and then we move on. So we don't wait for last minute, and then we're like, there with one question paper, and people pretending to be paying attention. So we do this, and then we move on. It's very easy. Question up to there? Before we move on to the next
I
part.
have a question.
Go ahead.
Does a promoter raise capital for the company?
Does a promoter raise capital?
Yes.
Not really. I mean, they could if they want, but the thing is, once you've registered the company, because if you're raising capital, the problem is where's the money going? Okay, because if people give you money for a company that doesn't exist, you see the problem with that. So your job is to make sure that that company is registered. Once the company has been registered, then you won't be a promoter anymore. So they're going to be directors and shareholders. And those people are going to be raising capital. The directors are going to raise capital. So, enter.
Okay.
Because if you start raising capital, then there is the question of where is that money going? Because this company doesn't exist. Any other question? Eric, do you have a question? Eric? Okay, so now let's move on to, so we understand promoters. Before we started registering company, blah, blah, we need to understand who are the people who are going to do this. Now let's talk about the process. So the process of registering a company will obviously depend on whether we are registering a public company or we're registering a private company, okay? What is the difference between a public company and a private company? We are tunajua before we even bother going into the details. The difference between a public company versus a private company. Apart from the spelling, what is the other difference? Yeah, Eric, you have to explain that. So what are the numbers? Number of directors, yes, but what are those numbers? Like how many for each? Go ahead, Eric. So in the case of a public, how many do you have? In the case of private, how many do you have? Actually, no. Those are just, no. In terms of directors, public one, public two, private at least one. We're talking about directors, we're not talking about members. In members, if you're talking about members, that is where you have 7 with no maximum, 2 to 50. So see, this is a good thing. This is why this is the reason why I insist on participating. Because sometimes you know something, but then you are confusing with something else. So you see, in that case, it's members 7, directors 2. Okay. Eric, are we together? Eric?
There's a difference in their formation. For private company, their business actually starts after issuance of certificate of registration, incorporation, sorry.
Yeah.
Then for public, no, it should be the other way around, sorry.
Actually, both will need a certificate of incorporation. So
yeah,
so that one is somewhat again. So you see, it's just that the main thing is that with private companies, you just private, as the name suggests. With public companies, at some point, that company is going to be owned by the public, either through IPO or if it is a parastatal, then through the government. Okay, so usually that's pretty much the whole point. But again, it's important. In fact, when it comes to difference between these companies, so let me just say pub and private. So one, there's the question of directors. So here, now remember, guys, directors are the people who are running the company. That is not the same as the people who own the company. Okay? The directors are people who are running the company. That is why you have the board of directors. So in a public company, at least 2 directors. But of course, it will depend on what the articles of association states. In a private, at least 1. In terms of members, now members could be the same as shareholders. These are the people who own the company, either through acquisition of shares, which makes them shareholders, or through the guarantee they give to the company, so they become guarantors. So in a public company, at least 7 members with no maximum, because you don't know. Like a company like Safaricom, how many members does it have? Well, it depends. As many as the people who bought shares, okay? With private, at least 2 members with a maximum of 50. So these are members. In terms of how do they raise capital? So public companies can raise capital from the public by selling their shares to the public. Now, private companies can only raise their shares in private, which means they can't sell their shares to the public. If they want to expand through sale of shares, they'll have to do it privately. They'll have to say, look, can you get us 20 people who can buy our shares? And then they'll approach, maybe they approach some rich guy and say, we want to expand. We'll give you 5% of the company in exchange for blah, blah, blah amount of money. You see, that's privately done. Okay. With public companies, they'll be required to do an audit. They'll be required to present their financial statements, make the financial statements public, which is not really the case here. Okay. Private companies don't even have to do the audit. They don't have to unless someone is complaining. But with public companies, it's a must. So anyway, these are some of the differences. Now, the reason why I bring these differences up is because when it comes to registration, the steps taken to register a public company are slightly different, with like 2 extra steps from those taken to register a private company. Okay, so let's see. If you're going to register these companies, let's start with the first one, the public. So first of all, okay, is there any question up to there before we move on? Question? All right. Now, first of all, okay, good. So you'll be required to submit your memorandum. Memorandum is for both, but for now we're just starting in public. But both companies will give a memorandum of association, whether it's public or private. With only that in the case of a public, it must have at least 7 members. Okay, with at least 7 members. So say 7 of them. This is just something short. 7 members who will subscribe to the name of the company. That is according to Section 4 of the Company Act. You don't have to worry about this. Just remember that and that. Okay. Now, this memorandum, first of all, what is a memorandum of association? Memorandum is a public document that explains to the public what the company intends to do. So this memorandum, and this is important because we may not really repeat these when you're talking about private companies because of time, right? So we need to finish this topic. So this particular memorandum here is going to tell us a bunch of things. It's going to tell us the name of the company. Okay. The name of the company with the word limited as the last word. Why is this important? What is the significance of this? I mean, if you see a company like A, B, C Limited Ltd, why is that important? What does that limited represent? What do you understand by that? Chap, guys. Eric, go ahead.
The word limited serves to inform the public of the liability of the company in case of the dealing with the company.
Yeah. So it simply means that the relationship you have with that company is limited, depending on who you are. If you're a shareholder, that relationship is limited to the shares you have. If you're a guarantor, it's limited to the guarantee you've given. If you're a supplier, well, it's limited to the nature of that contract. So the relationship is limited. Unlike others, like sole proprietor and things where we have unlimited relationship. So that's the first thing that the memo shows. Okay. It will also tell us where the company is registered. Okay. It will tell us the objective of the company and all that stuff. So these are things that are going to be brought out in the memo. I mean, we'll come and we'll come back to all that stuff. So now you already have your memorandum, which means, think about it. It's very important. You know, the memorandum explains the company to the public, to the people you're dealing with. These where being smart is necessary, because if you poorly formulate your company, okay, then the objectives are going to limit you. For instance, if you say that your company is going to be selling chairs or furniture, because a friend of yours just became a millionaire by selling furniture, and so you think, yeah, well, there's a lot of money to be made in the furniture business, and hence you join the business. Then you start the business, and then you realize, okay, this this furniture thing is not as good as I thought it was. Now you can't just switch. Because it will be like, hang on, you are limited to what? To furnitures. How am I limited? Simple. You are limited by your objects. So that's the thing. Anyway, we'll come back to that. So for now, that's that. So after you've written that, you also have to submit an articles of association. Okay, you'll see in a few minutes. What is it? You are supposed to submit a list of people who are going to be acting as directors and their consent. So these two things, this one and this one, are actually what separates the registration of a public company from that of private company. So in a private company, just give a list of directors. You don't need a separate list showing that not only are they directors, they've also consented. It's automatic. The directors, they've consented. Okay. So and then you give a statement of your nominal share capital, meaning what? Now that you're starting, how much is this company worth? And then another form showing that we've complied with everything that is legally required of us. Sawa. And then the registration takes place. And if the registrar of company is happy, you get your cert of incorporation. So question there. Normally when I'm quiet is because I'm expecting you guys to ask a question before I move on. Any question?
Yes, Mwalimu.
Go ahead.
After all these documents have been submitted to the Register of Companies, which one is first issued? Is it certificate of registration or certificate of incorporation? Or they are both referring to the same thing?
It's the same thing. Certificate of incorporation is the thing. Certificate of registration. What is certificate of registration really? Because you see, once you have a certificate of incorporation, it means think of a human being being given birth certificate. There's a difference between birth notification and birth certificate. Birth notification just says there's a human being. It is to notify you that a human being has been born. But this is not proof that the human being exists. Eric, I know that's a fast stretch, but do you understand what I'm trying to say there? So
if that is the case, then
so the incorporation becomes the proof that the company exists. It's like birth certificate, the human exists. Okay, continue. If that is the case, the left.
Yes. If that's the case, if you're saying they're the same thing, part of the note shared indicates that private company can actually commence their business upon issuance of certificate of registration.
Yeah.
But for the case of public company, it actually has to wait for certificate of incorporation.
Yeah, because here's the thing. You see, with private companies, first, which one is likely to do more damage? A public company or a private company? Which one is likely to steal a lot of money from people? I mean, they can both do that. But which one do you think the government is really interested in terms of how they're being operated? Public or private? Eric?
Public.
And that is the reason why public is going to be limited. Can you prove that you exist? Although even with private, it's like, yes, the business is registered. Okay, so start doing things because you exist. But now the incorporation is just that this is the prima facie proof that we exist, okay? But the thing is, even with that certificate of registration, there are things you can't still do. Like you'll go to a bank and they'll be like, we need your certificate of incorporation. Okay. I mean, you can start operating, like getting office space and things of that nature, but you're still limited. So, you know, there's something you need to understand about government operations. The government needs to make money. And the last thing you want to do is limit how entrepreneurs operate. So usually that's the reason why you have issues like those. But at the end of the day, the start of incorporation is the I'm saying prima facie, which just means on the face of it, the ultimate proof that the company exists. Although you can exist without, you can operate without those things. You just want to be, I mean, there are places where you want even, they want to, like in tenders, they're going to accept a tender bid with a registration that doesn't have incorporation. So it's, again, it's like having a notification with no birth certificate. Yes, you still move around. You have, but then there are scenarios that will be like, go bring the birth certificate now. Okay. So that's how that is. Any other question? So that's for the public. Now let's go to the private and then see. In the meantime, if you have a question you ask, you don't have to wait for us to like all that. Now with private companies, it's the same process except for this form and this form. Okay. So you'll still, there's something I needed to mention here. You know, when you're doing this, even in easy, but let's start from the scratch. Let's start from zero. When you're registering a company, first of all, you're going to do a name search. Okay, so you'll do a name search. If that name hasn't been taken, then good, you can proceed. So after the name search, and then now you obviously pay for the name search, right? And then you're given that that thing which tells you can use this name in the next, how many days is it? 30 days or something to just start business. 30 or 21, or whatever, I can't remember them. So there's that. And then after that, now you submit the documents that are required. So in this case, the memo, the article, the list of directors, list of members, and proof that you've complied with everything else. And in the case of a public company, consent of these directors. So once you've submitted all this stuff, then the registrar approves. That's when you get your certificate of incorporation. So there's that. So now, in case of a private company, what are we saying? In case of a private company, you're saying that you'll do all that. But then remember, unlike the public, okay, in private, the numbers of people involved, first, you need to have at least 2 members. You're saying at least 2 promoters. Because the assumption is these promoters are also going to become members. And then the rest becomes fairly straightforward. Any question? Question up to that part? Hunter, do you have a question?
I don't have.
Okay, so let's move on to those documents. Let's start talking about the memo. So now we have a memorandum of association. What is the job of this thing? Okay, and you see, the memorandum of association is the set of document that is designed to do one thing. Basically, it's designed to tell us what is that company all about. So the job of this memo is simply to define, one, the limitation of the company, okay, or limitation of powers of that company. So, you know, when something tells us what you can do, by telling us what you're capable or what you're going to do, you're also telling us what you are not going to do. Okay, that's how that operates. If you tell us what you're going to do, you're also telling us what you're not going to do. Okay, so because there's the object clause, which I'll look at, there's the object clause, that means everything that is outside that object, unless that thing is what is referred to as intra vires, then that thing is just pointing towards what the company isn't going to be doing. And so that is the memo. So the memo is designed for who? It's designed for the public. It explains to the public what the public can expect from the company. And this is the reason why later down the line, as we continue, we will see that there is this thing called the indoor management rule, okay, which will all depend on something like memorandum. So the memorandum is important because if you look at later, we shall see, not today, but when you're studying director, we shall see something called the indoor management rule. And the rule is fairly straightforward. It's that if you are dealing with a company, or if you're dealing with, well, it's just companies, then the assumption is you've read their constitutive documents and you know what they're supposed to do and what they aren't supposed to do. So the question can be, well, how am I supposed to know what a company isn't supposed to do and what it's supposed to do? Then it's like, have you read their memorandum? Well, how do I get the memorandum? Go and pay for a search. Go pay a search fee, give you a reason, and then you're given the memorandum, and then you can read it, and then you can figure out if that company can do it or not. So you can figure out the limitation of the company's power. Okay. To make it more simple, let me give you, look at this example here. Just understand something here. So we have two people. There's John and there's Jack. So let's pay attention. They all go to a bank to take a loan of 2 million. So on behalf of their company, okay? 2 million on behalf of the company. In this case, the bank asks John the purpose of the loan. And John says, the purpose of the loan is to start a school, to start nursing school. Nursing school. So they ask for the purpose. And in this case, they do not ask for the purpose. So they don't ask. Don't ask. And this guy uses the money to buy cocaine. Okay? So here, what is the purpose? To start a nursing school. Here, they don't ask for the purpose. The dude takes the 2 million and buys cocaine. Now, in both cases, I want to understand something. In both cases, like in the case of this company, this is actually a furniture company, which means they have no business starting a nursing school. And this is an IT company, which means they don't need cocaine to make computers work faster or something. So the question is, between John and Jack, so in this case, the company is called ABC Limited. And in this case, the company is called 123. So between ABC and 123, which of this company must pay the loan and which one can fail to pay the loan? Notice in both cases, the loan taken is something which is not part of their object clause. So which of these companies, in which case can the bank say you must pay our loan and they will win? And in which case the bank can say you must pay our loan and they will lose?
None of them will actually be compelled by the bank to pay the loan.
None of the companies, huh?
Yes, especially if John and Jack supply the company with the memorandum, supply the bank with the memorandum.
Okay.
Yeah.
So at this point, let's just assume let's ignore the memorandum thing for a while. Okay, or even let's say they have supplied the memorandum and all that stuff still. So generally speaking, yeah, but ignoring that, in this case, in the first case, ignoring the memorandum thing, let's not get so much into detail. In the first case, the ABC will just fail to pay that debt and they'll say John can pay the company, because it can pay the bank because the memorandum doesn't say anything about starting a nursing school. And in the case of a cocaine, this one looks illegal. So the fact that, in fact, let me even make it more complicated so the memorandum thing makes sense. They both supplied the memorandum. So Eric. So they both gave the bank the memorandum. But in the articles of association, in the memorandum, it shows that the company can take a loan, okay, of up to 3 million without involving directors or things of that nature. So they consider 2 million to be a small loan. So you see, in that case, the memorandum is just like, meh, okay? So you see, in this case, the bank can give the loan, but then, and then assume this is the ordinary course of business. But then the IT company will be forced to pay because it will say, okay, that loan was in the ordinary course of business. But in this case, the bank, the ABC's defense can be, yeah, well, even if it's the ordinary course of business, our memo doesn't say that. These guys can be in the ordinary course of business, our memo doesn't say cocaine. And then they'll be like, yeah, well, see, that's just the thing. We never asked what you're doing with the money. Okay. There is no rule which says we must ask you the purpose of the loan. I mean, we could ask. I mean, they are required to ask, but what if we don't ask? So you see, that's the thing. I mean, these are fairly oversimplistic. I mean, banks don't operate this way, first of all. So this is just a fairly simple example to explain something. This example is just designed to explain that companies or any other financial institution working with a company, or not just a financial institution, even you as a human being working with another company, if you get to a point where you're contracting and the money is such that you can incur loss, then you need to read their documents, understand whatever it is that you're about to do. Is it something that the memorandum has approved or not? Okay, because if it turns out that that thing is not in the memorandum, then that company is not going to be bound by that contract. And it doesn't have to be an extreme thing like cocaine in this case. It can be something as simple as the company contracts you to help them build cars, except the company doesn't deal in cars. Okay, so yeah, what is the content of a memorandum then? So let's go over the contents of a memorandum. So the memorandum of association. Okay, first of all, any question up to there? Any question so far? Okay, Planta, do you have a question? Right. So see, here's the thing. The memo will contain the following. These are the main things: the name, registered office, the object, the limitation of liability, capital, and association clause. So let's go over them quickly, and then let's see if you can take like a 5-minute break and then you continue. But if you're okay, you can still continue. So number one, the name clause. Okay, regarding the name clause. So the thing is, when you are registering your company, the name is important, and not just for branding purpose. That's the thing you have to understand. Most of the time, we just obsessed about, can we find website with that name and a CEO and YouTube channel? It's like, yeah, okay. But for legal purposes, the name is important. It's not just the name. So the memo has to show the name of the company with the word limited as the last word. And you've already established why that. So even if you call your company A Limited B, then you'll still have to add limited commercial. The limited is not part of the name. Limited is a description. Okay? The word limited there is a description. It simply describes the relationship of that company with pretty much everybody within the company gets into business. It's description. So the name. So limited is a description. So Safaricom, it's going to be Safaricom Public Limited Company. Okay. So that's a thing. I mean, you'll never really see these unless it's an official document. You'll just see Safaricom and then you're like, yeah. But that's the thing. So the memorandum has to show that. And that is important because that tells you the relationship that company has with the people with whom the company does business. Now, if you choose to, and then there are rules regarding the name, first of all, okay? The name should not be similar. Did I send you these notes? Just so we're on the same page. Do you have these notes? Guys, did I post the notes on Mkonazo?
Yes.
Oh, okay. So yeah, because I'm really summarizing things and yeah, so I hope if there is something I've said and it's in the notes and I've skipped it, just remind me because I'm not really like going through the notes. So the name shouldn't be similar with any other name because that is just going to be confusing. I mean, these are just rules. It shouldn't be misleading. So look, if somebody has their company and it's called ABC Safaris, then what comes to mind? Can this person tell you ABC Safari is actually, Safaris is a telecommunication company? Is it a telco company? If somebody says their
No.
company is called ABC Safari, see, that's misleading, right? We just assume it's a tour and travels company. But then if the argument is, but Safaricom, it's like Safari has that com at the end, Safaricom, which makes it a telco company. All right. So the name shouldn't be misleading. The name should not also give any association with the government. So you can't have your company called ABC National something of Kenya. You'll be like, nope, we don't want anything that will make people think this is a government affiliated business. Okay, so obviously it shouldn't also be offensive. You just can't have an offensive name and things of that nature. It shouldn't be having any attribution or any relationship to the royal family. Any Commonwealth country, these rules are fairly batty. You can't have a name that gives any association to the royal family or something like that. The King Charles and his cronies. So there is that. Then the other thing you have to understand is that if you yes, you can change the name, and you can change the name because you've been forced. So that becomes compulsory. Like when the registrar looks at the name and decides this one doesn't make sense, change it or figure out another name. Or you can change the name because you want to. Okay? You can change it because you want to. I mean, Airtel, currently it's Airtel. This thing wasn't Airtel. It started as Cancel when the Safaricom started, and then this one came later. It was Cancel, and then it went to Celtel, and then it was like Zain. Okay, and then it's Airtel. So all this stuff. Okay, so these changes were actually attributed to acquisition when the late, what was the name of that Muindi guy who died? Merali. So bought it and then all that stuff all the way into finally Airtel. So although Airtel isn't a change of name because Bharti Airtel is a big international company, it's just an acquisition here. Okay, so my point is, sometimes you can have your own company and then you realize this name doesn't really work the way you wanted. I mean, it was a fancy name, but then as you start doing business, you realize this name is not helping me to get customers. I need to change it. Of course, you'll have to give a notification of change of name. So that's the thing. Number one, name. Number two, you need to tell us where your registered office is. This is important because the primary function is just to tell the people that in case there are any legal documents here or notices or pretty much any other communication, somebody suing you, their auditors reports, somebody wants to know, to inspect the list of members, which is a topic we look at. Who are the members in this company? I need to see that list of members, things of that nature. Where can they go? So you tell them, here's where our registered office is, so you can go there and check it out. That's the primary function. Of course, most people don't even have this. Like, what happens is that you start your business. Let's say here's the thing. Right now, you have a smartphone of some sort. Then you decide to start your own YouTube channel or TikTok. Okay. So what do people do on TikTok? Like 90% of people on TikTok are just idiots. And I don't mean that in a bad way. I mean, they're just people who like dance to someone else's music or mime. Somebody says something and then they just move their mouth, and then there's that voice. And that's it. And then they say, well, I'm in TikTok. Now, let's say you're not one of those rubbish people and you decide to actually run a business using social media. So you can decide to register an actual business, ABC, okay? Business. Let's say you guys are accountants, so ABC Firm, which is an accounting firm. And then what do you do on YouTube? You actually talk about auditing or accounting problems and how you can help people to solve those problems. And then you do the same clips on TikToks. Obviously, you're going to get many views, because if you put anything smart on the internet, most people don't really care for that. People want to be entertained and to forget about their problems, and then they wake up with the same problem. So that's not really making you money. But now you want to make money. So notice you have this business, except you're running this thing from your house. It's just something you have a camera or your phone or everything. So you don't really have a registered office. So what most people will do is that they'll use, after they'll ask their friend, do you have an office? Yes. Where is it? And then they say, we are in Agwings, Kodek. Okay. And then they tell you wherever they are in Alingam, and then that's pretty much what you write there. So, and then, we just approve that. But in the reality, you don't have any physical location. You're running everything online. So most businesses are like that, because it's purely online. Maybe somebody watches a video and then they need to contact you. There's a list contact form there. They put their name. The thing is sent to your email. You give them a call. And then it's like, okay, so what's the problem? We talk about it. Where's your business? Well, our business is there. Like, I'll show up, you show up, fix their problem, blah, 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 you go away. So you see, that's something that can happen. But I mean, that's just a shortcut. But the truth is, you'll still need a physical office at some point if you're going to run a successful business, even if that means your house becomes the physical office. Then you have the object clause. So the object clause, what does it tell us? It tells us the main objects of the company. What exactly the company is supposed to do? Okay. What are the main things you're going to do? Okay. So that's important. And then there's the main thing, and then there are other things you could also be doing which are not part of number one. So in short, if all these is confused, just think of it this way. This tells us what the company is going to do, which means it also tells us what the company is not going to do. Okay, because if you say that I'm going to go to town tomorrow, then you just told us where I will not be. It means tomorrow I want to be in the house, I'll be in town. Okay, so that's the thing. But it's important for us to understand here that the objects are a way in which you try to control or to limit the power of an artificial person. Remember, a company is an artificial person, because human beings are natural persons. And the law doesn't put a limitation to a natural person. If you start a sole proprietor business, you can do anything you want to be a sole proprietor. You can sell planes, and then tomorrow be like, okay, selling aeroplanes is not even fun. Let me sell houses. Let me even sell food. You can do all that. No one cares. The only problem is that people are not going to be doing big businesses with you, because sole proprietor is a risky business. But because that the business and you are the same thing. But if you start a company, it's an artificial person. And so we can't allow it to do anything and everything, because then there won't be a difference between a company and a natural person. So we're going to cap or to cut the powers of a company by limiting it to what is stated in its objects. So anytime, okay, you go beyond what the object clause states, then you say you've gone beyond the powers of the company, which means whatever you are doing is beyond powers. Okay, so ultra vires simply means beyond powers. So for example, if you start an IT or ICT related company, and then you decide that you also want to invest in real estate. So we look at your object and say, no, you said IT and IT related. Real estate is a different thing. So to avoid this problem, because any contract you get into where you are buying houses and selling them under that company's name, those contracts are going to be declared null and void on what grounds? On grounds that they've gone beyond the powers given to you by your object clause. So how do you go around this? Usually, you either buy shares in a real estate company, okay, because that one is possible. So ABC is an IT company, but ABC wants to do real estate, okay? So choice one, the people who formed ABC can form 1, 2, 3, which is a real estate company, and then have that 1, 2, 3 bought by ABC. that ABC becomes the parent or the holding. This one becomes the subsidiary. And then have people work in the real estate company, make money, and that money goes up here. That's one. Two, you can just buy shares in a company that already is doing real estate. And that way, this ABC company still makes money from real estate in addition to IT. Tunaelewana? Do you understand each other up to there? Otherwise, the real estate contract becomes beyond powers ultra vires. Are we together? Any question? Guys, come on, changamke. We're about to have a 5-minute break or something. Are we together up to that part? Okay, so let's move on. And then don't worry, we're about to have a simple short break and then we continue. Right, so now these are ultra vires, but then we have intra vires, which is the implied powers, okay, within powers. So there are things which, remember what I've said, whatever you've written is what you're supposed to do. But then there are things which you can do, but you did not write them in your memo. For example, a company can borrow money. Okay, there is a loan. Yet they never wrote loan as part of their business. A company can buy shares. Basically, can acquire other company. Okay, a company can sue. Company can be sued. So these are things you never really wrote in your memorandum. They are implied. Okay, they are within the powers. They don't go beyond the powers. So this is what we refer to as intra vires. So the question of whether an action is intra or ultra will usually depend on the nature of that action. Is it something that is an extension of the object? For example, if you have an IT company, you're repairing computers and doing all that, but then you decide to sell softwares, somebody can say, but you did not try here to sell softwares. You said, and any other IT-related services. Maybe there's a clause saying that. Any other IT object, any other IT-related services. So softwares are going to be part of IT-related services, even though we didn't write precisely the word software. So that is still going to be within the powers we have. Okay, so that's that. Now, what else do we have here? We have, in addition to this, we have the limited liability clause. So this one tells you the degree to which a company's liability is going to be limited. Okay, and that in terms of the relationship with the company and the people who own it, that liability, as we saw in topic 1, can be limited by shares. Meaning what? Meaning, if you order 10,000 shares in a company and have only paid for 7,000, which makes 3,000 unpaid 3,000, then your relationship with that company, as far as the company is concerned, the company only owes you whatever the 7,000 shares are worth. Hiyo ndio deni yao kwako. Even if that company makes billions, the amount of money that you can take from that company is only whatever the 7,000 shares are worth. If it is profit, then whatever the 7,000 shares represent when they're doing dividends and they're distributing profit. Now, as for you, what do you owe the company? You owe the company whatever the 3,000 shares are going to be worth. So in that case, the liability is limited by shares. But if you promise to give them money, in short, you guaranteed. You guaranteed to give the money. So then your liability towards the company is limited to whatever it is that you guaranteed. If you guaranteed to give them 50K, depending on the terms, then that is how much you owe them, even if you're a billionaire. So that's that. Okay. And then the capital clause, these are much nominal. And we'll see this in topic 4. These are much nominal capital the company is worth as at the time when this memo is being written, the memorandum. Any question up to there? Any question? Okay, so can we take a 5-minute break and then we resume, finish the rest? I need to know if you're together because you're quiet, so you can Like, can you guys confirm, verbally confirm or whatever through text? Because it's now 8:40. 5 minutes break. Okay, Eric? All right, so 8:45, we'll be back to proceed. All right, so now, yep. So that's the thing with the memo. Now, the thing you have to understand about the memorandum is that it's legally binding. Okay, that's the cool part about it, or the weird part about it. The people who subscribe to the memorandum are going to be legally bound, meaning what? Number one, the terms of the memo, which pretty much what you agreed on, is going to be like a binding contract between the company and the members. So remember, the memo is saying these are the company is going to do. Okay. And it's also telling the people in the company, this is what you expect from you. But the people are also saying this is what you expect from the company. Now, all acts done by the directors, okay, or in this case, the member, beyond the powers of the memo, we've already established that will be ultra vires. And if anything is ultra vires in a memorandum, it means the company is not bound. So when your company is supposed to be dealing in metal fabrication, okay, and building bridges, and then things metal related, and then you say we also want to go into the hospitality business and start cooking food, then as we pointed out, it's either you ratify the memo so that it includes food, or you just start another company or buy another company that does that. So, and then again, remember, members cannot ratify an ultra vires act even by unanimous resolution. What does that mean? This is what that means. If, let's say today is 9th, so let's say on 7th, guys decided that in a company that was the IT company, now IT company, on this day, the members decided that we are going to make some money in real estate. Okay, so just talking. And then on 9th, somebody's trying to sign a deal. Okay, a real estate deal. Now, first of all, that is not in the object. But then you're like, okay, let's do this. Now that this deal has already gone through, let's just all vote to say it's okay. The company can now do real estate. It's like, it's only okay when I'm doing this deal on 11th. It's okay from 11th going forward. Anything 11th going backward that you had done that wasn't part of the company object is going to be ultra vires. So even if you all agreed, just agreeing going forward, that's the thing with the law. Anything ratified in the law usually takes effect that day going forward. Everything from that day going behind is not covered by this new law that you've just created. So that's the reason why we are saying that even if you have, okay, even if you have these, what is that? Where is that? Right. Okay, here it is. So even if you have this resolution here, okay, being unanimous, it doesn't bind the company because you're doing it at the wrong time. So that's pretty much the thing with that, okay? Of course, these actions, if an act is, given by the memo, that is, it's intra vires within the power. But then the same thing is contradicting an articles of association, okay? Then the members can change the articles. It's easy that way. So because there are times when the article and the memo can conflict. So just go ahead and change the article. Remember, the article, as we shall see in a few minutes, is internal. It's not as complicated as the memo. The memo is external. The article is internal. So that's just a thing that the directors can change. Okay. Of course, again, if the directors end up doing something that is ultra vires, then that particular director can be compelled. For example, if a director decides to buy a car, this is a car, the director's car, and yet there is nothing in the memo that says anything about directors having cars, okay? Then just tell the director refund the company. So anytime you do anything that you want the company to be bound, but then it turns out that thing goes beyond whatever we expect from the company, then that's on you. The company is not going to be bound. Okay? So remember, contracts which are ultra vires will not bind the company. Even if we say that the aggrieved party can have some relief, like having the directors pay and stuff like that, but still the company isn't bound. So those are the rules regarding memo. Now let's move on. We were supposed to have breaked here, but so now that we've already taken our break, let's talk about the articles of association. So any question up to there, any questions regarding promoters, regarding the registration, regarding memorandums, before we move on to the articles? Any question? Clemta, Eric, Sarah, how are you doing? Any question? Okay, so do I take the silence to be let's continue? Good. Right, now let's move on, right? So let's talk about the articles. Now the articles is internal. Remember the memo was external. The article is just a document which is supposed to tell the internal management of the company how to do things. In fact, let me break it down. Let's just see. This is what the company looks like. So you and your friend started a company. At this point, what are you? You are promoters. Okay? Started a friend, you're promoters. Then in the process, you end up succeeding in registering the company. So now in this company, you can either become directors or you can say you want nothing to do with it. But let's assume you're directors. So as directors, you could set up a board of directors. And this board of directors can end up either appointing one director to be active as the managing director, or you can have a CEO, or if you really feel like you're American, you can have a president. Because I don't know, Americans just have this thing where they make big names for very petty positions. So there's that. Okay. And then remember, there's the company itself where you have HR, financial manager, mtu wa mkono, is that also a name? Whatever, all that stuff. These are just employees. So this is actually the company. This is the company's management. Okay. And this line here, we shall look at in a few minutes, is what we call the veil of ink. We'll still end up just repeating this drawing anyway. But the point is now, upper at this level here, we need something that is going to guide the operations at this point, okay? We need some guidelines for people operating at this level. And those guidelines are what are going to be stated in the articles, okay? So the articles of association is supposed to sort this problem here. What can directors do? What can the board of directors do? What can the managing director do? Okay, what kind of particular, what do you expect from shareholders? Because again, as I said, promoters, I forgot to say here, you have members or shareholders. So these shareholders appoint directors who appoint board and blah, blah, blah. So what do you expect from these people? That is where the articles of association comes in. So remember, the memorandum just tells the public what we expect from the company. The articles will not tell it sort of says out from the company. So from the articles, what do you expect? First of all, there is the preliminary contracts, if any. Remember, we started by talking about issues to do with pre-incorporation contracts. Remember this question that we looked at? So there was this question that we looked at here, okay? And in this question, you could see the issue here was the preliminary contract, pre-incorporation contract rather. The idea that Tom actually goes ahead and registers Tom Company, but then Tom negotiates a lease agreement. So during this process, Tom is obviously incurring some expenses, and those expenses are supposed to benefit this company. But then, as you already saw, a company is not really bound to pay a promoter. The promoter can't be, I created you and therefore you have to pay me. That will be an equivalent of a parent telling a child, but I gave birth to you in Kakulipia school fees, you need to pay me. The kid's rebuttal will be something like, I didn't ask you to do that, did I? So the company can just as well as say, well, I didn't ask you to do to treat me, so whatever. But if we are doing this, and because there are two things, there is disclosing conflict of interest and disclosing profit. So if you've disclosed all the expenses, which is something that Tom should be doing here, as you saw, if you disclose all the expenses and the receipts to justify those expenses, then it means in our articles, we can have any preliminary contract. What are the contracts that were gotten into before the company was created? And what are those expenses? Okay, so preliminary contracts, even pre-incorporation expenses, if any, those are going to be stated, and not only stated, but how are we going to deal with such? And then there is the number and value of shares. When you start talking about shares, we'll talk about that. There is the question of share certificate. See, there's a difference between share certificate and a share warrant. We shall see that in topic 4, but anytime, okay, when I talk about shares, what comes to your mind? Anybody? Go ahead. Eric, Sarah, Planta can answer that question. What do you understand by shares? You could just say it. I mean, you have to type it. So when somebody says shares in a company, what comes to mind? We already had a break. So mmenyamaza mko wapi? Eric?
Shares.
Mm-hmm.
Number of capital contributed by each member.
Okay. Well, that's one way to look at it. So that could be, I'm not saying that is it. I'm just saying that's one way to look at it. So when somebody owns a portion of the company and the corresponding equivalent of how much that portion is worth becomes a share. So if they get that share, something that proves that they own those shares is a share certificate. Now, if a member takes a loan in relation to those shares, so lien on the member's share, okay, how many shares are we holding on to because somebody took a loan and they put up the shares as a mortgage? In short, they mortgage the shares, they put up the shares as security. So that one is also going to be stated in the articles. All right. So you see, running a company is not just a simple idea of I have products going to sell. You're never going to become a billionaire doing that, right? You do realize that, right? I mean, at most you become a millionaire. But the moment you start playing games at this level, think of it this way. I don't know. Once you understand the idea of money, there are things which you start seeing things at a very different level. Like it's very hard to convince somebody that I can sit in the house the whole day from 1 to 30 and dress up in a t-shirt and probably sweatpants and then still pay rent and do all that stuff. If that person is somebody who knows that you have to wake up, go to work at 8, I don't know, what time do people go to work? And come back at 5 or something, whatever. And then do this on Monday to Sunday, because that's their mentality. So the same thing, playing these games. So like when you see a billionaire, any billionaire you can think of, right? And then they say, this guy is worth 300 billion, whatever. And somebody actually sits down and thinks they have, okay, let me just, let me, Somebody thinks that this person has a bank account that has 300, okay, 1, 2, 3, 4, 5, 6, 7, 8, 9. Somebody thinks that that person has a bank account that has that much. No, they don't. Okay, this is just valuation. And the valuation is based on what? It could be based on the shares they have in a given company. It could be based on the worth they're putting to a certain asset they have. Basically, it's just their net, like they've paid all their debts. This is what they're left with. That's just valuation, which means if the shares drop, this value drops. And so when the person goes and takes a loan and puts up the shares, then that's what happens. The value is just dependent on whether they pay that loan or not. So the point here is that once you start looking at these things from that angle, you realize it's a different game, okay? But anyway, we'll see that when you're doing shares. For now, I just want you to understand that, yes, somebody can put up their shares as loan, and that will be indicated there. Transfer, transmission, forfeiture of shares, alteration of capital. This one is going to be topic 5. So what are the rules regarding changing our capital structure? Because we can choose to reduce the capital, we can choose to increase the capital, we can choose to, well, cancel some of it. Okay, rules regarding meetings. Should we pay directors? Remember, they're not employees of a company. Okay, if the answer is yes, then how much? Okay, should we declare dividends? What are the conditions? When do we do audit, if at all we do audit? If you want to wind up, how do we do it? So these are some of the things that are going to be mentioned in the article. Remember, if you look at all this stuff, they just point towards internal guidance, okay, or rather management of that company. They just tell us how do we manage the company. That's pretty much what they're saying. So the other thing you have to understand is that now this stuff here is going to be legally binding. The same way the article was legally binding, is the same way this thing is going to be illegally binding. And so in this case, the article will say constitute a contract, which is going to bind both the company and the members the same way the memo was. And that's pretty much the thing. So I don't like go over that. So any question regarding the articles of association that you can think of? Any question? Question? Right. So if there's no question, let's move on to the consequences of incorporating a company. So if you form a company, then what are the consequences? What do you think happens once a company has been formed? What are the consequences of forming a company? Short, what happens to the company? Come on.
It becomes a legal person has been created.
Right. And so what does that mean? That legal person, what are some of the things that the legal person can do?
They can now commence business. They can, in their own name, they can sue and be sued.
Right. So when they can own property. Okay, good. So when we talk about consequences, those are the things we're talking about. It's just like, okay, yeah, so we created a company. What happens to that company? So the company can, first of all, it's liable for its own debt, which is cool because, look, as I keep on telling you, people form companies for many reasons. Just that economic situation, Kenya or even Africa, or the mindset people have, is such that you have a guy, okay, I'm just going to use John because I'm not imaginative when it comes to them. I have a guy called John who says, when I grow up, I want to be rich. And John thinks if I start a company called XYZ, and that's it. So I really have to work for this company XYZ. Yeah, but then you have another person called Jen. And Jen also just wants to be rich. But Jen doesn't want to do anything. So she just ends up forming like 5 companies. So company A, company B, company C, company D, company E. Like, why are you having all these companies? I don't know. And then company A doesn't do anything other than just buying shares in other companies. That's it. That's all it does. It's not even operating. It's a trading company. just an acquisition company. That's all it does. Where does it get money from? From company E, which sells chips. And tunakulaga chips na nini? I don't know, I'm too conscious of food, whatever, chicken or something. Now those people who think it's cool to buy chicken at KFC, they even take pictures. They're like, and to eat KFC, I'm an idiot. You're just eating nonsense with the flavor. So anyway, so they have this company just sells food. Whenever the company makes profit, probably the company, which it's a company, right? Notice it's a company, but then that company, this company which is ours, owns this company, probably owns like 90% of that company. The 10% is just there in case she needs to like raise capital. So whenever this company makes profit, 90% goes to A. What does A do? I just takes that profit and say, who's that? That's Tom. What is Tom doing? Tom has a salon. Okay, let's acquire shares in the salon. That's it. So now whenever Tom's salon makes profit, inaenda kwa A. Who's this guy? This one is another guy. What does he do? Well, he has a spare parts business. Is he looking for a partner? Yep, let's give them some money. So, and then he has company D, which does something else, and that maybe this one is an educational company. What does the educational company do? Nothing other than produce videos for YouTube and sell online courses. So where does the money go? Probably just find its way to company C, which probably is owned by. So the person just structured the companies that way so that you don't even understand. What about B? B is just a company that deals with labor. All employees that work at E, D, and A, in fact, A doesn't even need employees, but whatever. All these employees are not directly employed at C, D, and E. All these employees are employed at B. And then C and D and E contracts B. So these employees, whenever they're having issues or strike all you want. Okay, it's never going to affect this one and this one. It's going to affect this one. So your contract is with this one. We pay the money they pay you. Meanwhile, John is struggling na hii kampuni moja and sijui loan and nini. And then now John is indebted. The whole XYZ is in debts. So now John has to close this company. But you see, at this point, if this company goes down, it's like, bye. Just open another one here. Okay. And the money was. So my point is, when you understand these companies, when you look at the consequence of incorporation, the part that a company can have its own debts, okay, and the company's operation are going to be limited. This should tell you how powerful the idea of companies are. It's only that now you think, I want to register a company, I need at least 8,000, I must do 10,000, whatever it is. I don't have that. And so that one 10,000 in Nikonayo, if you register a company, then I really have to hold on to it. It's like, maybe, but as you're growing, why not register another? Okay. So it can own property. Maybe that's all you do. Okay. You know, there's there's this thing here that and the ladies who are here, you can speak if I'm lying. There's this thing here where you have a man and a woman and they're in love, and usually the brain is no longer functioning. So usually at this point it's just a lot of pheromone and whatever. So there's wealth. And then will you sign a prenup? So if the man has money and tells a lady, sign a prenup, what does the prenup say? It says, my money is my money, your money is your money, the money that we make, that one you can share in case you break up. The lady will be like, so are you saying you're going to break up? So if you don't want to have this problem, then just have a company and then have that company on property. Of course, that still leaves the problem of your shares, which means then have a proxy, someone else you trust. Okay, who can't run away with your mom? Because, and don't be like, it's my mom. Your mom can just steal from you. Your mom is like any other woman. The difference is that you share DNA with her, or your dad, same thing. So I'm not saying they're bad. I'm just saying if you trust them, good. If you don't trust them, find someone you trust. So whether it's your dad or your brother or whatever it is. I mean, these are people like anybody else. Okay. The fact that you share DNA with them doesn't make them saints. Okay, so you can have that, let's say woman or that. So the company's purpose is just to hold on to property. So if things go wrong, it's like, okay, we are divorcing and I want 50-50. It's like, good. My KCB account has like 15,000, so you can take 50% of that. What about the company? I only own 2% shares, which by they have never really paid for. So technically I owe that company money. So unless you want us to share that debt. Right. So there are ways in which people can protect their property through companies and through trust, although you're not studying trust here. So anyway, the company can own property, the company can contract, the company can borrow money, the company has perpetual succession, which means if the owners of that company die, we'll just have new share. Like right now, Naivas, it's not now, it's like 2 days ago. So this guy is the founder, that the dad died. Okay, it's not like if he died last year. So the guy died anyway. And one of his sons who also had like shares died. So these other siblings are suddenly in court fighting over control. The same thing that happened with Tusky. So you see, problem kama hizo, most of those problems occur, and the fact that those shareholders can be kicked out unless something happens doesn't mean that we can't have new shareholders. Okay, so that is unlike a sole proprietor where the founder dies and the business is over, because the business and the owner are the same thing. Anyway, those are the consequences. Any question before we move on to something else? Question? Sarah, now that you joined us from swimming work, late. Any question? Eric, Planta, sorry. Okay. Eric, Sarah, no question. Eric, question?
None.
Right. Okay, question. So let's move on to the veil of incorporation, which is a different thing. Now look, here's what we mean by the veil. The veil of incorporation is just it's a veil that is supposed to separate. You know, the idea that a company is not the same as the people who own it, or a company isn't the same as the members. Okay, that idea is what separates. It's what gives the company what we call its personality, the legal personality. Okay, and that thing is safeguarded by whatever is called the veil of incorporation, which is a fictitious screen separating the company from the individual. I mean, this is pretty much what that looked like. I said we'll come back to that drawing again. So when you start a company, you have shareholders. Let's assume you have shareholders. Okay, or could say members. Now, these members are not all interested in running the company. It's like if you have money and then your friend says, I have a business idea. So it doesn't really mean that you want to be part of running the business. You probably just give them money and say, okay, you tell me what I'll be getting every whatever period. So these are shareholders. So the shareholders decide on who the directors are going to be. And by extension, the board of directors. So basically, this is the management, okay? And maybe they end up having an MD or a CEO. We already saw this on it. CEO. So what is happening here? This constitutes the owners of the company and the management of the company. But this is not the company. So these people here aren't the company. The company itself is here. Okay? So the company is what people see, where we have the employees or we have the services and all that stuff. Okay? Although the product you are interacting with, sometimes you think that it's not. Like Facebook, whatever you are doing, Facebook itself, the thing that you're logging in, that's the product. So it's just a what is it called, social media platform. But then Meta, the company that owns it, although there's Facebook itself as a company. Right. So this thing, the fictitious thing that separates these people from this part, is what we call the veil. And this veil is as a consequence of the company being incorporated. Once a company has been incorporated, it becomes a person. So to guarantee that personhood, we say this is different from that. Are we together? So the problem is not the veil. The problem is sometimes things could be happening here. Like, are you guys doing financial management? Anybody who's doing FM here? Right. So in FM, there are those things called the equity problems. Okay. The fight between the shareholders and the management of the company. So the shareholders think, we are putting money in the company. So you guys should only be focusing on one thing. Profit maximization. You need to make as much profit so that you can get as much dividends so that the shares can go up so that you can be happy. Wealth maximization. And this thing where you guys are just for the management, where you're like giving yourself salaries, it's guaranteed, using the corporate jet, going to those stupid things that people go to do in Mombasa, you retreat and I don't know, whatever, those things. You take pictures and you post on social media. Meanwhile, our stock price is going down. Meanwhile, the shareholders' value is not being maximized. So there's a problem. The problem is who really controls the company. So to avoid those problems, okay, sometimes the shareholders might say, oh, we want to know, what do people do? And then the management might say, oh, no, we just can't show you everything about the company. The company has its own privacy. I mean, it's a person. So here are our financial documents. And then, there's a difference between the published documents designed for the public and the actual financial, like the income statement that is going to be gazetted is a summative one. You just say sales, whatever million. But then the one that you get as internal staff is actually going to be breaking down whatever constitutes this number. So when these people say we want to see this one, the companies will be like, nope, veil of incorporation. We're not showing you where on hii yenye tumepatia this summary one. So that's where the problem of the veil of incorporation comes in. Okay. And so in exams, you might be asked, under what circumstance can the veil of incorporation be lifted? Okay. So when can the court say, okay, we need to know what's happening in that company. We need to lift that veil of incorporation. We need for the actual event going on in the company to be shown. So this is usually when, number one, let's say, doesn't really go in this order anyway, but number one, when there is some fraud or some improper conduct, you think something isn't going on according to plan. Okay, are we using this company to hide money? Because you can do that. Okay, so let's forget about the company having its own privacy. Let's do some audit and forensic. For the benefit of revenue, maybe the company is just cheating on its taxes. Okay, and the tax man is interested in getting his money or her money. If the company is an enemy character, let's say Kenya. Apparently, Kenya is just picking fight with all other countries on TikTok and Twitter. Just not like it's fun. The Kenya versus Burundi, Kenya versus Nigeria, whatever. Or in Twitter or whatever it is. Anyway, so let's say Kenya is an actual fight, not those nonsense, the hashtag. So let's say Kenya is at war with I don't know which country now. Uganda. I don't see the reason why we'll probably be at war with Uganda, but let's say that. So it means all companies, all Ugandan companies that are in Kenya, you're going to start suspecting these companies. Are you guys just making money so that you can send it to this year so that you can fight us even more better? Suddenly we'll start saying, okay, we need to see where this money going. So you saw that when the US just wanted to bring down Russia and then they proxy war where they pay Ukraine to fight Russia. It's kind of funny. Yesterday, Tucker Carlson interviewed Vladimir Putin, and suddenly all the European Union were like, he's a traitor. Why? Because he interviewed the guy and he said, let's hear what this guy has to say. People are just weird. So anyway, in that case, if the company is an enemy character, so you want to know. So in that case, we probably lift the veil of incorporation. Okay. Where the company is a sham, like you create a fake company for many reasons. I mean, people do crazy stuff. You can create a fake company because you want to swindle money. So in that case, we'll be like, what is this company doing? If you're avoiding your legal obligations, remember what I started by saying, you can create a company to avoid legal obligations. If I say avoid legal obligation, it sounds like if it's a bad thing, but that's not the thing. Like, let's say you want to, okay, here's an example. you know, let's say you want to minimize how much tax you're paying. Okay. So we know, you can just do sales and then gross profit, blah, 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 and then expenses and then profit and then tax. So if you can inflate your expenses, if you can inflate cost of sales, then it means you're going to pay less tax at this point, right? Of course, there's a problem of the VAT, and if you're using the other, the term or whatever, but still, these are things you can manipulate. Or you can just outsource some of these services, okay? Like labor, if you realize labor is costing you more, I mean, forget about the corporate tax. If you have to pay, what is it, that money you pay for employees? The social NSSF, whatever it's being called now, and those amount of money, then you can just say, okay, you're going to use labor from outside. So Safaricom does that with customer care. Those people don't work at Safaricom. So you have another company XYZ here, which by the way you own, okay? This company owns XYZ, and then that company is the one that handles marketing. So anything to do with marketing, run it through that, and then have them inflate the marketing expenses so that now you have a big bill here, so that you have less profit and you pay less tax. So that can happen. The same thing can be done with labor. They can inflate the labor cost. I mean, the worker is still being paid 25,000, if that is the case, but doesn't really mean that is the money that we pay here. Here we say we are paying this company 35,000 per worker, and then they can choose to pay 25,000, and then the 15,000 is their profit. So now that means here. Of course, when it comes to here, we also figure out how to move it around. So again, as I said, when you start looking at how money moves around, things are different. But if you are restricted to how much salary you make, then you just have a myopic view of money. So companies can do that. The problem is that if it turns out you're really doing that simply for the sole purpose of avoiding some legal obligations, then we might say, okay, let's see what is actually happening in this company. Okay. In case the company is created as an agency, like those real estate agents, and the principal is in doubt. So agency means there's a principal. And this principal, maybe the landlord thinks, why are we, like, I'm paying you a what? So that can happen. For trust. And the beneficiary, okay, of that trust fund thinks the trustee is doing some shady deals, then we might say, let's leave the development corporation. Again, if you're avoiding welfare, or simply for public interest. Welfare ni vitu kama hizo NSSF, or for public interest. Then we will say that so-called veil, let's get rid of it. The shareholders or the members and this company, let's put everything to light and see what's happening. Question up to that part? Any question? So look at this question here, which pretty much in your handout. So in your handout, this is the one that I sent, right? You have these two questions, which my assumption is now you're in a position to answer them. Guys, are we still together? Are we together? Can you see the question?
Yes.
All right, let's finish this and then we are done. So mchangamke. So at this point, you should be in a position to explain the memo, the article, the difference, okay? The details, okay? Outline rules that govern pre-incorporation contracts and cite relevant cases to support your answer. Which means you can make up something, rich. You have Baxter, which is in your notes. You have this one, which is just an example of somebody hiding secret profit, failing to disclose. So there are those. So you can try and do these questions. If there is any issue, you let me know. Okay. So is there anybody who has a problem here? Remember, when it comes to answering questions, it's kind of easy, these cases. Okay, there are many ways to do it, but for me, I usually prefer one, look at the facts of the law. Next, look at proof from the case, and finally, comment. Like in this case, Kyoko, who is a secretary, blah, 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 in blah, blah, blah. So Kyoko, what does he do? He invited bids for members of the public to buy 2 lorries. he also bidded through a nominee, Mwangangi, who's his brother. So this guy creates a company, and then his brother comes and bids, and then he sells the lorry to the brother for 80K, okay? And then forms a company, right? And then they sells the same lorries to a company for 350. So he's making a secret profit, the difference here. So what is the issue here? The issue here is that the person hasn't disclosed profit. That is what the law says. Okay. So at any given point, we're told that that promoter has a fiduciary duty, meaning promoter must disclose any secret profit to who? To the shareholders or to the board of directors, or they must disclose any potential conflict of interest. So this guy failed to disclose that. So the fact is, those are the facts need to disclose. The guy failed to disclose that because you're told you did not disclose. So what are the consequences? Well, he has to account for this profit, okay? Or sell the lorries to the company at an actual price, because the company is not going to pay for something that was void based on the evidence you've just given there. And so that's the conclusion. So number one, facts of the law. What does the law say in relation to that case? Which means if you don't even know what topic that case is coming from, you're going to have a problem. Number two, proof from the case to support what you've just said here. And then, so you can look at that. And then conclusion. So when you're told to advise, this advice is just the conclusion based on facts and proof from the case. I mean, fact from the law surrounding the case and evidence, and then conclude. So today, unless somebody has a question, today the whole point was just talk about topic 2. How do we form a company? So you've seen there's a way, you've seen precisely what is it that promoters are, what do they do, what are their liabilities, do we pay them or not? And then registering a business, is it a public, is it a private? And if you're going to register, whether it's a public or a private, the documents you provide, so the memo, what is it? What does it contain? What are the legal repercussions? The same with the articles. And then the consequences of incorporation, the veil of incorporation, and grounds for lifting or piercing the veil. So in the next class, we'll look at topic 3. So that would be on Friday. Any question? We call it a day. Any last concern or something? Yeah. Hata hapo tumenyamaza kwa last concern or last question. Okay, have a lovely evening. See you in the next class.
Okay.